Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about exceptions to the admissibility of relevant facts. Don't forget that in my last episode, I already discussed two exceptions, as we could see in section 1A of the Evidence Act. So now, in this particular class, we start with the case of HARUNA versus AG, where it says that once a piece of evidence is relevant, the court is bound to admit it. That's like the general rule, like I already told you in the last class. Once a piece of evidence is what? Relevant, the court is what? Bound to admit. However, there are 5 different exceptions to this rule. The first one is when it is too remote. I already told you section 1A of the Evidence Act. The second one is when the law renders evidence inadmissible according to section 2 of the Act. Now, section 2 of this Act tells us that relevant facts shall be admitted unless excluded by the Evidence Act or any other legislation validly in force in Nigeria. So you see, now section 2 tells us that if this Act says a particular relevant fact is inadmissible, then it's inadmissible. Do you understand that? That's number 1. Number 2, if any other legislation which is validly still in force says that a relevant fact is inadmissible, then it is inadmissible. Do you understand that? So we then move on to the case, that is the case of SUBERU versus SUMONU, where the Supreme Court held that a document may be relevant and still be excluded if there is in existence a law which renders it inadmissible. For example, an unregistered deed of conveyance. Do you understand? So if you've done land law and all that, you should know that a deed of conveyance, which could be an assignment or any other, should be registered for it to be tendered as evidence in court. That's to show not necessarily ownership, but to show that you have interest on the land. Do you understand that? So then we move on to the third one. In the interest of justice, evidence may be excluded if it unfairly treats the accused. E.g., a particular victim makes a dying declaration, "This man has killed me." Though relevant, it will be inadmissible against the accused for it being imprecise to which him. Do you understand? So the court has the discretion here in the interest of justice to exclude certain evidence, even though that particular evidence could be a relevant piece of evidence. Do you understand? We are talking about dying declaration, for example. Now, this person has come to say, "Oh, this man killed me." That's what the victim said. Do you understand? The victim said, "This man killed me." Yes, it's very relevant to put that in evidence. But then, against the interest of justice, anybody could be this man. Do you understand? Anybody could be this man. And therefore, if the court is to admit that, it will be prejudicial to the accused, because he did not expressly say that Akin has killed me. Do you understand? Even if he says Akin has killed me, there are a lot of Akins, but in that particular environment, there was only one Akin. Do you understand? So, because somebody cannot be dying and you say, "Akioluwa Jayola have killed me." Do you understand? So you need to then be reasonable. But to say this man is too broad, because you might be the only man there, but still you might not have been the person. Anybody could have been this man that killed him. You might not have been a victim of circumstance, but it's less likely that you are the second Akin that was there to be termed a victim of circumstance. Do you understand? That's very less likely. So we then go to the third one. On the ground of public policy, as we can see in section 308, where evidence against the president or governor, and the last one is where that particular evidence is illegally obtained. Illegally obtained evidence, for example, where you did not take the consent of the person before you, for example, you wiretapped the person's house, so yes, there's a murder case and the person was granted bail, under house arrest. The person cannot leave the house, but is under the close watch of police and all that. Now, while the person was in his room with his wife, you wiretapped the house and you were able to get the communication where he confessed to his wife that he committed the offense, and now you want to bring that to court and tender it before the court. It is inadmissible. You shouldn't. That is illegally obtained evidence. It is relevant because that is a person actually confessing, but that evidence was illegally obtained, and because of that, it is an inadmissible evidence. Although there are certain exceptions, But at this point, let us have it at the back of our minds that illegally obtained evidence, although relevant, is still inadmissible in the court of law. And those are the 5 exceptions to the rule that all relevant facts are admissible. In my next lecture, we are talking about the res gestae rule. The res gestae rule. I really love that topic, and I hope that you pay very apt attention when I teach. So I will see you in my next lecture where we talk about the res gestae rule.